Welcome everyone to our webinar on unfair contract terms, the Fujifilm decision and what this means for businesses. My name is Robert Chen and I am a senior lawyer in LegalVision's commercial and corporate team. I'm joined today by my colleague Paul Wright, who is a practice group leader in the commercial and corporate team. And so we'd like to start with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present, and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Before we begin, a couple of quick housekeeping items. First, you'll be emailed a copy of this webinar. You'll also be able to submit your questions in the chat box. And if you get the chance to, please complete the survey after the webinar. It does go a long way to us providing these types of services to you guys. So also, all attendees are eligible to receive a free legal consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today we will be discussing the following topics. What are unfair contract terms? When do unfair contract terms apply? Paul will take you through the ACCC and Fujifilm case, as well as the implications for your business, and then we'll finish off with a Q&A.
Thanks, Robert. So firstly, looking at what are unfair contract terms, in what context does the legislation apply, and particular things you need to look at. So if we start at looking the unfair contract regime, or essentially what we mean by that is the legislation that imposes these requirements on contracts that deal with consumers or small businesses. The key thing is that those unfair contract terms are void if the contract is a standard form contract. So there's a couple of key concepts here. Firstly, is the contract a standard form contract? And we'll look at a bit what that means. And secondly, is the term itself unfair? Now, I guess with all of your businesses, you're not going to be able to change whether the counterparty or the customer is a consumer or a small business. They're defined terms that will be driven by your business model, and you're not going to be able to change anything through contract or corporate structuring to change that. So a really quick key question is whether the contract you're using is a standard form contract. If we take a further step back and think about what is the policy driver of this legislation, the policy driver is really a concern that consumers and small businesses were being forced to enter into contracts that had terms that were unfair to them, and they were not given an opportunity to fairly negotiate or change or amend those terms in their best interests. So this piece of legislation is really focusing on those standard form contracts. And what do we mean by that? So it essentially means a set of terms and conditions that are presented to a customer or counterparty on a take it or leave it basis, typically prepared by one party, and the customer or counterparty is not given an opportunity to negotiate those terms. So looking at some very simple examples, in the consumer space, a product or service is offered to consumers, such as a SaaS platform or an online service. They're given a pop-up box with terms and conditions to read, and at the end of it, they click a box saying I agree, and then complete their purchase. In the small business space, it might be a set of terms and conditions that are included on a website or printed on the back of an order form. They're then incorporated in a form of contract, such as a purchase order or a standard form order, and the customer or counterparty is not given a lot of opportunity to negotiate those terms and conditions. Now, one thing to note is that it's very much a substance over form approach when determining whether a contract is a standard form contract. This means that simply asking the customer or counterparty, do you have any comments on the terms and conditions before signing, is not really enough to move it out of the standard form basket. There needs to be a good faith engagement on the terms and conditions, a good faith negotiation. The customer or counterparty needs to be given an opportunity to meaningfully engage with the terms and conditions. And your business needs to have, I guess, a practiced habit of engaging with those customers and small businesses and consumers with respect to those terms and conditions. So there are a number of considerations there to take into account as to whether or not your contract is a standard form contract. Do keep in mind that simply sending an email asking if they've got any comments or questions is probably not enough to move it out of the standard form basket and therefore move it outside of the operation of the legislation. The other key concepts obviously are, is it a consumer contract or is it a small business contract? So consumer contracts, we're talking about the supply of goods or services or a sale or grant of an interest in land that's predominantly for personal, domestic or household use or consumption. And in relation to small business contracts, again, we're talking about the supply of goods or services, sale or grant of an interest in land, but there are a couple of other key thresholds or gates that need to be met. The first deals with the price. So the upfront price does not exceed $300,000, or if the contract is longer than 12 months, $1 million, and either party has under 20 employees at the contract date. So there are some additional questions you need to ask, particularly if you operate under a B2B model. Some things you can do in that space are build it into your procurement process, getting that information from the counterparty. But do keep in mind that there is an obligation on you to meaningfully engage with whether or not the counterparty is a small business, and if so, engage meaningfully on the terms and conditions. Otherwise, it will be a standard form contract, and the unfair contract term legislation will apply. I'll throw it back to you now, Robert, to talk us through some of the exemptions and exclusions.
Thanks, Paul. So with this regime, there are naturally going to be some exclusions and some excluded terms. So excluded contracts, and a lot of these will make sense for obvious reasons. These will include contracts which have been entered into before the 12th of November 2016. But this exclusion won't apply to any of those contracts which parties have had the chance to negotiate and renew these contracts again. So the idea is that any sort of contract which has a 5-year or 10-year term that has been long been negotiated, they're not going to come within the purview of this regime. The next one are some of your other industry-specific ones, such as shipping contracts, as well as constitutions of companies, managed investment schemes, or other kinds of bodies. Now, in the contract, there are some terms which won't come under the purview of this regime as well. So, and when I'm referring to regime, I mean the unfair contract terms regime that exists under the Australian consumer law. So these excluded terms will include terms that define the main subject matter of the contract, and also terms that set the upfront price payable. And that's because the parties would have often had the opportunity to already have a look at the price before agreeing to go through with the contract or not. And also terms that are required or permitted by law. And examples are, any sort of terms which are permitted under the franchising code or another prescribed industry code. Now, taking a look at when is a term unfair, well, this really does come, this really is a matter of the court to take a look at the situation, take a look at the circumstances, the contract itself, and then make a determination of whether or not a term is unfair. So in the legislation itself, there are 3 key criteria which will assist us as lawyers and also assist you guys in getting a good idea of whether or not a term is necessarily unfair. The first of which it is unfair if it causes a significant imbalance in the parties' rights and obligations under the contract. When you look at a contract, it is ultimately an agreement between 2 parties. Now, we also need to consider that the 2 parties will often start from different positions as well. One party may be more powerful than the other party, one may be bigger than the other party. And so you already need to consider what sort of relationship exists between 2 parties. Often when you are dealing with a larger company, a blue chip company, or a company where they do use more standard form contracts because they are engaging with and selling to the consumer masses, then you're often going to find yourself in a position where you are starting off with an imbalance of power. And so if there's a contract with a term and that term does create even more imbalance, or I guess it could even start off with embodying that imbalance to begin with, and then if it amplifies that imbalance, then you potentially got a term there which is unfair. So an example of that would be, if there's a term which gives a party significant more rights in relation to termination, and if that party already begins with significantly more power, then that term could potentially create some sort of significant imbalance in a relationship. The next one is that it's not reasonably necessary to protect the legitimate interests of the party who would be advantaged by the term. And what that means is there another way under the contract, or maybe there are other ways in the contract in which that party can actually protect whatever interest that they're seeking to protect anyway. So where the court will then start to look at is if there's a couple of terms in the contract here which maybe do or might cover off on the same and protect the same legitimate interest. So that then takes me to the third one there, which is ultimately if it causes a detriment, and that detriment doesn't necessarily need to be financial, if the other party relies on it. Then the court will then look to other matters, and specifically the court will then turn to the contract as a whole, which means they will be looking at how the different terms in the contract are drafted between the parties, what sort of aspects of the relationship are handled by those terms. And so when they look at the contract as a whole, they are really looking at, how many clauses are mutual, what sort of rights does the smaller party have under the contract, and taken into context, does the contract as a whole, require a certain party to improve their positions, and then to the extent which is readily available to a party, which basically means the parties do have to have the opportunity to view the contract and see the contract. It can't be here's some terms and conditions, but we're not going to we're going to put a hyperlink to the remaining terms on our website. And then finally, whether a term is expressed in plain language, is legible and is presented clearly. So that does go a long way, and I guess places a lot of emphasis on clear drafting and plain English approaches.
Thanks, Robert. So we've had a really important decision in the federal court recently dealing with unfair contracts terms, and this was in relation to Fujifilm. So there's two sides, I guess, to this one. It does give us some improved clarity on the operation of the legislation and how the ACCC views it and how the courts will view it. So that gives some good benefits, I think, to business and to legal advisors about how this legislation will be interpreted and enforced. But on the flip side, it's a pretty big win for the ACCC, and it's likely to embolden them further. And so I think it should also put businesses on notice in this space that the ACCC is likely to pursue and investigate more rigorously, perhaps than they even have in the past. So the facts of this case are essentially that Fujifilm, a brand we're probably all familiar with by name, supplier of various goods relating to photography and printers and software. Since November 2016, it entered into or renewed a really large number of contracts, 34,000, and most of them were standard form contracts. So the ACCC was interested in these standard form contracts, and particularly some terms, particularly in its leases or licenses of office equipment and associated support services. Now, probably the way this eventuated or came to light was the ACCC was tipped off by some unhappy customers of Fujifilm. I guess it's possible that the ACCC was doing a general audit, but having worked in the enforcement space previously, I do know that a lot of these cases commence with unhappy customers. So an unhappy customer or range of customers have probably tipped off the ACCC about Fujifilm's contracting practices. The ACCC has then gone out and commenced an investigation, gathered as much information as it could about the terms and conditions of the contracts and the nature of the customers. and it has then gone and initiated proceedings in the federal court. So just I guess a sideway point on that note is that the ACCC does not have the power to unilaterally determine in this space. It will always flow like this, that, you know, the ACCC will commence an investigation and then look to commence proceedings, and it's only the court that has the final say in determining unfair contract terms. So what were some of the findings in this case? The court found that there were 38 contract terms in 11 different small business contracts that were unfair contract terms, and as a result, the court declared that they were void and unenforceable. They made a number of orders which will have a direct impact on Fujifilm's existing contracts and future contracts. So some orders were made that Fuji is prevented from enforcing these 38 contract terms in their current small business contracts, and they're also unable to incorporate those terms in the different forms of standard contracts for the next 5 years. So interesting there on the timing point. As Robert was speaking, courts will look at a range of factors in determining unfair contract terms. They'll look at contracts as a whole, they'll look at the various positions of the party, the legitimate risk issues of the parties. So Robert's going to talk us through very shortly about some of those key findings, but it is important to underline that this is not a definitive or the definitive list, and different terms in different contracts and different contractual arrangements, including over time, will determine whether or not the terms are unfair. Furthermore, Fujifilm must go out and notify all affected customers of the void terms. And as we noted previously, there were over 30,000 standard form contracts. Now, that in of itself is going to be a big compliance and regulatory task for Fujifilm over the coming months. Separately, they've got to implement an internal compliance program, and they're going to have to pay some money out of their own pocket to go to the ACCC's costs. So that gives a pretty broad sense of the way in which this can have a really large impact on businesses if they do include unfair contract terms in their standard form contracts with consumers and businesses. And I'll throw back to you, Robert, to talk us through some of the key findings.
Thanks, Paul. And Paul's exactly right in that this is not to be taken as like a definitive list of what are the unfair contract terms to look out for, although they do give a pretty good indication. And the legislation does provide that these, the legislation does provide for the three key criteria to be met, which is that significant imbalance in terms of the party's contractual rights and obligations. Is it necessary? Is it reasonably necessary to actually protect the party's legitimate interests? And then whether or not there's been detriment suffered by the party. So that then gives it quite a bit of flexibility to look quite holistically, like Paul's saying, at a number of terms, the circumstances, the facts. So let's click through this quickly. So these are some of the terms that the federal court deemed to be unfair or declared to be unfair contract terms. So an example here is set-off rights, and set-off rights basically prevent the other party from sending off amounts owing under the contract. So for example, if Fujifilm owed you a certain amount of money, there's a clause in the contract which allowed them to unilaterally take that amount that's owing and then apply it or credit it towards another amount into the contract, then those types of terms, because of a unilateral nature, were deemed to be unfair. Basically allowing another party, and you'll see this to be a recurring theme throughout these terms, is if there's a term which unilaterally gives one party the ability to make a decision that has an impact or can cause detriment to the other party, then that's going to raise some red flags. The next is automatic renewal terms. So if the contract is automatically renewed for a further period and the customers don't notify Fujifilm within a certain number of days before the end of that term, then the contract will renew for potentially maybe 12 months, or it could be even longer than that. So the issue with these types of terms is there's a really short, usually a short time frame in which a party needs to then, the customer needs to then positively notify the other side, Fujifilm in this instance, and the failure to do so will then result in that contract term being renewed, which potentially then locks in the customer for a very long period of time under the existing arrangement, which could also contain a number of unfair contract terms. So it's basically a continuation of I guess the unfair nature of the agreement.
Mm-hmm.
The next is
Robert. I might just jump in very quickly there, and just I guess because this is going to be a key point for businesses. Naturally, if you're running a business, there's an investment made up front. I guess a bit of friction in getting new customers on. So it's very appealing to have these rollover periods and to make the renewal process and keep them as a customer for as long as possible, as frictionless as possible. So it's a very common term. I think it's important to note that the result of this case is not that you're prohibited altogether from having automatic renewal terms, but you do need to look at the nature of the renewal terms, the rights that you're giving the customer, the amount of notice they need to give in order to prevent the automatic renewal. But you also need to look at their rights after the renewal. So if the existing term is let's say 12 months and it's going to automatically renew for 12 months and they've got to pay all of that up front again, you may want to look at the renewal being, giving the customer some additional rights to terminate in that extended term. That's one way you may look to mitigate it. Alternatively, you may look to build into your onboarding and customer experience process some direct engagement with the customer before the automatic renewal occurs. Because again, I think the concern from the courts and the ACCC here is that these contracts get signed, they're standard form contracts, so customers and counterparties may not have closely looked at the terms initially, rightly or wrongly, but then they find themselves locked in for extended periods of time without any further direct engagement on the contract process.
Yeah, exactly right. Thanks, Paul. And so moving then to the next one, disproportionate termination terms was something that's been identified by the federal court as well in this case. That's because Fujifilm had a number of other options in terms of terminating the contract, whereas the customer wouldn't have the equivalent or corresponding ability to do so. And so any sort of terms which give one party significant, much more freedom to terminate the contract will then again also be something of concern and something to have a look at. With the limitation of liability terms, so this was obviously flagged to be an unfair contract term and declared to be one because in this particular case, and there were a number of contracts and different types of contracts, but in the bulk of them, Fujifilm's liability was often limited to a certain amount when the customer wouldn't have a corresponding limitation of liability. And on top of that, you'd also find in most of the contracts that the customer would have to provide an indemnity in favour of Fujifilm without the corresponding indemnity. And obviously there are situations where every contracting arrangement is different. The risk profiles of the parties are often going to be different. So there are going to be situations where an indemnity is appropriate, and that's when you'll need to, I guess, speak to a lawyer, ideally, to work out what is an appropriate indemnity. Is this indemnity appropriately drafted, and then is the liability cap also appropriate for this nature? The next one then is the termination payment terms. So Fujifilm required customers to pay exit fees to Fujifilm upon termination, or in order to terminate and exit the arrangement. And some of these fees would be often disproportionate to the loss, if any loss, Fujifilm would have suffered in that instance. So there are question marks here whether or not these exit fees may be considered penalties. And so you'll need to give that a bit of consideration as well as to whether or not, and that could be potentially some sort of a bargaining chip you can potentially use, when you're negotiating, is that if a fee is, and this would require a bit more consideration, but at a high level, on the face of it, it could be considered a penalty and therefore unenforceable. And so Fujifilm was reprimanded for those termination payment terms.
Yeah, Bobby, just quickly jumping in there again, because particularly in a subscription business model or long-term contracting business model, exit fees are quite an important and somewhat contentious element, and we deal with this a lot with our clients. Again, I don't think the takeaway here is that you're not allowed to impose exit fees, but it should give everyone a bit of pause for thought about the quantum of those exit fees and the circumstances in which they're imposed. So we still think that in circumstances where you're offering large discounts to clients to commit for a long period of time, and they look to terminate early for no reason or fault of the service providers, there still is scope to include reasonable exit fees or termination fees. But you do have to, I think, in this context, in the unfair contract term context in particular, make sure that they're extremely reasonable, make sure they're justifiable based on some sort of higher service level you've given as a result of the long-term commitment or as a result of the discount you've offered. It's certainly not going to be acceptable to make clients pay out the entirety of a subscription, of a 5-year subscription, when you're not going to provide 5 years worth of services.
Exactly, and it comes back to that proportionality as well in terms of the fees. So there is something, like Paul was saying, there is something you can do about it, and there's something you can look to include it, but it just needs a bit of extra thought. So payment terms as well. Customers were I guess, contractually obliged to pay Fujifilm for example, the software licenses, whether or not Fujifilm had actually delivered the software license. So that's one example. There were also other issues in terms of the actual delivery of hardware and delivery of goods. And customers are often required, for example, pay the purchase price. So that's something, I guess, this is probably one of the more self-explanatory ones, where if you are going to be providing a service or a good, then and if the customer is going to be paying you, then you do have to be delivering upon that contractual promise. And then finally, unilateral variation terms, and this one is a nice one to recap on a bit. Because it really hits home that theme of Fujifilm being able to unilaterally, and unilaterally basically meaning that without consultation with the customer, without applying any sort of threshold in terms of reasonability, or being reasonable about a particular decision or about a particular move. Fujifilm was just able to, at its own discretion, unilaterally make a number of changes, and that included changes to the price. And so there are ways in which you can include this, address this in your contracts. But Paul, did you want to speak to this one as well about some?
Yeah, I guess, yeah, I mean, very, very briefly, it all comes back to fairness and reasonableness and giving customers or counterparties the rights to respond to that. So having a unilateral price increase that you can impose at any time during a 5-year term, and the customer can't do anything about it, is going to likely be problematic. But if you're able to, if you have the right to increase the price and they have a subsequent right to potentially terminate the contract, that's a lot less problematic.
Yeah.
But just conscious of the time, we might move along to some key takeaways now. I guess the first thing that I think is really key is to review all of your existing consumer and small business contracts for potential unfair contract terms. That's just a simple due diligence exercise. Depending on what you find there are certain next steps you can take. At one end of the scale, varying the contracts to improve the terms with existing contractors, but at the other end of the scale, at least changing those unfair contract terms when you enter into new engagements from this point forward. The same goes with drafting new contracts, keeping in mind the unfair contract regime, keep in mind the point I made a little earlier that we do have some better clarity as a result of the Fujifilm decision, and we likely have a more emboldened ACCC in this space who have a good win under their belts. On the flip side of the coin, if you yourself are a small business negotiating with a large business that is trying to impose their standard form terms and conditions on you, and you're not getting a lot of movement or traction in negotiating terms, gently prompting them as to your position as a small business and the operation of the legislation may give you some additional leverage to improve those terms. And finally, just keep in mind that there are some reforms coming to the legislation, and this is likely to include the introduction of harsher penalties. So it wasn't relevant in the Fujifilm case, but in particularly egregious conduct in imposing unfair contract terms, courts do have the ability to impose large penalties or fines on businesses that fall afoul of the legislation. That brings us to an end of the substantive point of our presentation today. We do have some time for some questions and answer, so please use the function in the webinar to do that. While I give you a moment to do that, a bit of information we'd like to share with you that we think you might find useful. We have a great commercial contracts checklist that's very user-friendly, very commercial, and you're able to download that by accessing the handout section in the webinar panel. Second, we have another great webinar that's really useful for startups called Startup 101 Understanding Term Sheets. That's on this Thursday at 11 a.m. It will be led by some members of our corporate team who are leaders in the startup space. So please register at the link provided. Finally, just wanted to mention the type of service that LegalVision provides, because it's a little different from the traditional legal model of hourly rates. We offer a subscription model, so for a fixed monthly fee, you get a whole range of benefits with a lot of cost certainty. This includes unlimited document drafting and reviews. It includes unlimited legal advice consultation with one of our specialist lawyers, and we have a team of over 100 specialist lawyers. We cover areas obviously like commercial contracting, but also franchising, corporate governance, employment. We also offer unlimited trademark registration, and all of this comes for a very reasonable monthly fee that gives you a lot of cost certainty. You know, again, like I mentioned, we do things a little differently at LegalVision. We kind of see ourselves as being, you know, an extension of in-house counsel. So if you're a small startup business and you don't have a legal function, joining a membership gives you some of the benefits of that in-house function. We work really closely with businesses to understand their needs. We take a very commercial and timely approach. And similarly, if you're a small business with an existing legal team, we can work really well with existing legal teams to supplement and complement and offer further services for the business at a very cost-effective way. To learn more about how the membership can help you, please request a free consultation when the survey appears at the end of this webinar, and please remember to put your contact details in. So now we'll turn to some questions that we received, and I might throw across to you, Robert, for the first one.
Thanks, Paul. So the first one is, why was Fuji Xerox's automatic renewal term considered unfair, and what would be a fair renewal term to have on a 5-year agreement? Now, the judgment that is available to us doesn't go through the details of why that specific automatic renewal term is considered unfair, and so there's that to flag at the outset. But as I was discussing when I was going through that particular slide about the automatic renewal terms, I think this is where the court is really looking to the contract as a whole. And so obviously there's been, you know, up to 38 unfair contract terms which have been declared unfair contract terms by the federal court. And so it's pretty obvious that the customer is dealing with a pretty one-sided agreement. And so having an automatic renewal term, which then, like Paul was saying, if it, for example, is a 12-month term and then it renews for a further 12-month term, and the customer has had little opportunity to then, you know, notify Fuji that it doesn't want to continue with the agreement, then it's basically locking itself, the customer is basically locking itself into another 12 months of engaging with Fuji under those various unfair contract terms as well. So I think that does go a long way. And it's, to Paul's point, you also need, the court would have had consideration to that amount of time that the customers would have had, and then, you know, even after renewal, to have perhaps more opportunities to exit the agreement if that was the case, or if that was the customer's intention. So, and what would be a fair renewal term to have on a 5-year agreement? I think this depends on the context of what the business is doing. And but if I was to just take it at face value here, a fair renewal term on a 5-year agreement, I think the parties, if we're talking about a 5-year agreement, then both parties would be, I guess, aware that this is going to be a fairly long engagement. And this would then provide, you know, some certainty as to, you know, as businesses would obviously like to have that certainty in terms of having your forecasting in place and everything. So That being said, I would, without regard to the background, having something like a 2 or 3 year, probably 2 year engagement with a renewal for renewal periods of 1 year plus 1 year plus 1 year is an option there. So I hope that answers that. Paul, if you had anything to add, or if you wanted to take the next question on.
Yeah, sure. Yeah, no, I guess the only thing I would add is, it is very context specific. Just sometimes it's best not to think of things necessarily as what is the right extension period for a 5-year contract, but to sort of step back and look at what are the expectations of the client? Is it reasonable to lock the client in for extended periods? But also, aside from the requirements under the legislation, sometimes the best risk mitigation is just to engage really honestly and early with potential customers, and deal with that renewal process early in the piece, separate to what the contract says. And if they have issues with the renewal process, getting ahead of it in a commercial sense as well, I guess, is another really important bit of advice we generally give. Another question here, is it possible to acknowledge in the contract that the terms in an agreement or contract are fair and reasonable, and that each party has had legal advice on the terms? So this is a really good question. It's a kind of boilerplate provision that you'll see in commercial contracts generally, outside of the unfair contract term legislation. Unfortunately, in this context, having that provision is not going to do anything to change the operation of the legislation. So including a clause like that is not going to be sufficient to overcome unfair contract terms, if any, in the agreement. And I would go further, even having a more longer form clause that expressly refers to particular clauses and says the parties agree to them is not going to be enough to overcome the fact that those terms may be unfair. But I guess step back a little bit and just keep in mind that the regime only applies to standard form contracts. So the question here is a very good one, and that term still can have a lot of value in contracts, but it is a substance over form approach, and it's really a question of making sure that if you want to include terms that are a little more onerous or potentially unfair, giving the counterparty the opportunity to negotiate and comment on those terms. And giving them sufficient time and then engaging in good faith on their comments is a really great way to mitigate that risk in a way that a simple provision like that just won't do in the context of the legislation. Well, we probably have time for one more if you've got one.
Yeah, so I'll take the next one, which is, does a small business contract have to meet all of the 3 dot points or only one? I believe that's in relation to the 3 criteria that I mentioned earlier about how there needs to be a term that causes significant imbalance between the parties and their respective obligations and rights under the contract. And then the second criteria, which was the term was not reasonably necessary to protect the party's legitimate interests. And then finally, that the party relied on that term to its detriment. So that one is a pretty straightforward answer, and it does need to meet all 3 of the dot points, and that's prescribed under the legislation itself. Back to you, Paul.
So yeah, we do have a bit more time here now. I've got another question. How do we handle termination for convenience clauses that are over and above other termination clauses? How is it handled in the court of law in case of unfair termination? So a termination for convenience clause, just by way of background, basically gives one or both parties the right to terminate the agreement on the providing of a particular period of notice. And it may be, for example, 30 days or 90 days, something like that. So compared to termination for cause, where you've got to establish that the other party has breached the contract or has done something, not in accordance with the contract, and you need to establish that the breach has been made. A termination for convenience basically gives one or both parties the right to walk away from the contract on the period, on the provision of a period of notice. So these again are not uncommon clauses. Generally advise, if we're advising businesses, the key consideration here is, well, do you want your customers to be able to terminate for convenience? And that filters through a little bit to the nature of the providing and the business model itself. And so, again, if you're offering a long-term contract based on a particular higher level of service or discounting, you may want to you may want to give some in-depth consideration to giving the customer the right to terminate for convenience. But in the context of the unfair contract term regime, I think the real key driver on termination for convenience provisions is reciprocity, or making sure both parties have the same rights. So we typically advise that if our client is the service provider and they want a right to terminate for convenience on a particular provision of particular period of notice, the customer should also have that right. And if the business doesn't want the customer to have that right, well, then business will probably have to accept that it can't have that right. And so in terms of how they're treated like any other provision. They themselves are not inherently unfair, we don't think, but it's really important that that both parties have the same rights, and that's something that Robert mentioned a little bit earlier about Fujifilm getting into some trouble for having a broader range of termination rights than their customers had. So we do have some good federal court guidance on that, and I would just point out that, yeah, one, keep in mind that it needs to be reciprocal, but two, keep in mind whether giving the customer that right or you retaining that right makes sense within the broader business model that you have.
And I might just quickly add, I know we're just,
yeah, sure.
sorry, just mindful of time, and but to add to that just quickly, the final point, the final criteria, which is, a party needs to rely on it to the detriment as well. So you need to think about how, commercially, is it justifiable? For example, like Paul was saying, you've got 30 days for termination for convenience, so 30 days notice is given. But for example, if it's a construction site and you've got a termination of convenience and it's 5 days notice which is given, well, that's going to cause a lot of detriment to the involved parties, because all of a sudden you have to demobilize your workforce, your personnel, you're dealing with all these other contingent contracts as well. So it just needs to have regard to the commercial setting and the facts and I guess that context as well.
Yeah, that's a really great point, Robert, and I'm glad you actually mentioned that. It's not just a question of reciprocity. Robert makes a really good point there that there are also broader considerations given. Again, like we've mentioned a lot through this, having regard to the nature of the services and the impact it's going to have on small businesses or consumers. So that's a really great point. That brings us to an end today. Really appreciate everyone for joining us. Just wanted to make one final point. You can request a complimentary consultation today. So all webinar attendees are eligible to receive that complimentary consultation. We can discuss with you how we can help you with your business contracts and any of the other legal needs, whether they be in employment or corporate. So to do that, please leave your contact details in the survey that appears after the webinar ends. Really important that you leave your details so that we can reach out to you and get in contact. Otherwise, thank you very much for joining us, and all the best.
Thank you. Thanks again.